Hello, welcome. Thank you for joining. My name is Peter Calabrese. I'm the CEO of CanAm Investor Services. CanAm Investor Services is the FINRA registered broker dealer affiliate of CanAm Enterprises, one of the largest and certainly most successful regional centers in the history of the U.S. I have the great pleasure today of being joined by Mr. Nicolai Hinrichsen and Ms. Kristal Ozmun. And we're going to be talking today about hedging one's H-1B status and using the EB-5 program and concurrent filing for doctors and other professionals as they make their way through the EB-5 and immigration process. Nicolai, Kristal, both of you partners at Miller Mayer, one of the finest law firms in the EB-5 industry. Thank you so much for joining. And please, if you'd like to give yourself a quick introduction.
My name is Nicolai Hinrichsen, as you said. Thank you. I'm the managing partner of Miller Mayer's EB-5 practice. Thank you for the kind introduction to Miller Mayer. We've been around since the EB-5 program started way back in 1993. And by volume, I think we are one of the largest EB-5 law firms operating in the space. So I'm delighted to be here today to talk with Kristal and you about EB-5 and the opportunity it presents for H-1B holders.
Thank you, Pete, for having us here today. As Pete mentioned, I'm the managing partner of Miller Mayer's General Immigration Practice Group. But I also do a significant amount of EB-5 work. So today we thought we would discuss some of the areas of intersection between the two with you. So in particular, we'll focus on H-1B status for EB-5 petitioners, as well as adjustment of status. And I'll start with sort of a quick summary of the H-1B classification, and then go through some advantages and disadvantages of the category, some specific to this administration, some not, before Nick gives us a closer look at EB-5 and adjustment of status. So what is H-1B classification? So H-1B classification is generally for professional workers with a bachelor's degree or higher who can work for up to 6 years in what's called a specialty occupation. So that's a weird word. What's a specialty occupation? So when we think about a specialty occupation, we have to keep in mind that it's one that requires at least a bachelor's degree or higher in a specific field. And there's two really critical components in order to get H-1B classification. So the first is that there has to be a very tight correlation between your degree and the position that you seek to fill. So like if you're someone who has a degree in fashion and you're seeking a position as a mathematician, that doesn't work for for H-1B purposes. It's more if you have a mechanical engineering degree and you're seeking a job as a mechanical engineer, that's a good fit for H-1B classification. The other thing that's really critical to the category is that the employer has to pay you a required wage. And that wage is the higher of the prevailing wage or the actual wage for your specific position in your specific area. So what are the advantages of H-1B classification? So there are quite a few. Ultimately, you can get up to 6 years of H-1B classification and additional H-1B extensions beyond the 6th year in one of two ways. One is if you start your if you start your green card process before the end of your 5th year in H-1B status, or you have an approved I-140 or an approved I-526 petition before the end of your 6th year in H-1B status. Contrary to what I think is popular belief, there's not actually an advertising or test of the labor market that's associated with H-1B classification. And there's little to no delay when you actually have to change employers. So a thing called porting enables you to commence employment with a new employer as long as that employer has filed an H-1B petition on your behalf. It does not necessarily have to be approved. Another benefit, but also something that I'll mention in the context of disadvantages, is there is spousal work authorization for H-4 holders, but it is very, very limited. So what are the disadvantages of H-1B classification? So H-1B filings are always employer, occupation, work site, and wage specific. That means that every new employer that you have has to file an H-1B petition on your behalf. It also means that any changes to your job, to your work site, to your wage always have to be analyzed to determine if an amended H-1B petition is required. This year, potential disadvantages for H-1B holders include, of course, the H-1B proclamation that came out. I want to say it was September 21st of last year. So what that instituted was a $100,000 fee applicable to petitions filed on behalf of beneficiaries outside of the United States. A second new introduction that complicates H-1Bs is the weighted selection rule that's applicable to the lottery. So what that effectively means is that positions that have higher wages have a greater chance of selection in the lottery now. So if you are at what's called their level 4 wage, which is the highest wage level you can be at, you effectively get 4 shots at the lottery versus if you're in an entry level position and you have a level 1 wage, you only get 1 selection. So your odds of getting selected in the H-1B lottery are now much reduced in comparison to past administrations. Again, I mentioned this as a benefit, but it can also be sort of a downside, which is the limited work authorization for spouses. So H-4 spouses are only eligible to apply for work authorization when the H-1B holder has an approved I-140 petition only. And the I-140 is the penultimate step in the green card process or the normal employer-based green card process. And it takes about 2 years minimum to reach that step. So that would be, that would be well down the road for individuals who are in H-4 status. They would be here without work authorization for quite a long period of time, potentially. And that also assumes that at the end of the day, your employer even agrees to sponsor you. So it's not a given. They have to decide when and who they'll sponsor for permanent residence. So you don't necessarily even have that opportunity, depending on the facts of your situation. And probably the biggest downside, of course, to the H-1B category is that there's a finite number of H-1Bs available each year to individuals in the private sector. So that means that even if you get an employer to sponsor you, you may not get a number in the lottery and thus work authorization. And you have to keep in mind that the lottery occurs only once a year. Again, the chances of selection are potentially much reduced this year, depending on where you fall in the wage spectrum. So just to give you sort of an idea of what the odds are, keep in mind that there are 65,000 H-1B numbers available to those with bachelor's degrees and higher. And then there's an additional 20,000 available for those who have U.S. master's degrees or higher. And in 2025, for all of those 85,000 slots, there were over 470,000 registrations, 470,000 for 85,000 total slots. So that gives you an idea of what your chances are in any given year. In 2026, just this past year, they were slightly lower, but it was still around 350,000. So you are up against sort of great odds if you are going into a private sector job and you are vying for one of these H-1B numbers. So I'll stop there and turn it over to Nick to sort of talk to you about what EB-5 looks like and how it might help you to sort of navigate some of these issues.
Yeah, thanks, Kristal. So before we get into the real benefit that EB-5 can offer somebody who's facing some of these challenges that Kristal has outlined, let me take a minute to describe what the EB-5 program is. To give people a sense of what the opportunity is. So EB-5 stands for Employment-Based Fifth Category, and it is a immigrant visa category that allows an individual to make an investment in a project in the United States. There are actually kind of two EB-5 programs. There's what we call a standalone program where an individual might make an investment in their own business. Those are extraordinarily rare. It's very difficult to invest your own money in a commercial venture and have your immigration success really riding on your own the business success of your own venture. And certainly, when we're talking about H-1Bs, that's not a pathway chosen typically by H-1Bs. The other program, if you will, and Pete referred to this a little bit earlier in terms of a pilot program, that's the Regional Center Program. And the Regional Center Program was enacted by Congress in 1993, and starting in about 2008 became extraordinarily popular during the first financial crisis, emerging as a source of alternative financing for real estate projects. And since then, the popularity of EB-5 has grown exponentially. So it requires an investment. The current investment amount is $800,000. And it requires showing that that investment has created 10 jobs for U.S. workers. The nice thing in the regional center context is that job creation is accomplished by way of economic modeling. So it's much easier than it is in a direct structure to show and demonstrate ongoing job creation. And perhaps most importantly, in the regional center context, regional centers like CanAm really stand side by side with individual investors, helping them to satisfy the immigration requirements in terms of participation in the business and so forth. So it's a relatively passive investment, which is why it's suitable for individuals, who are in H-1B and who are otherwise professionally engaged.
Oh, thank you, Nicolai. Very helpful. And as I take a quick pause here for a second, I should have mentioned at the top, this is all such fantastic information, but it should also not be construed as legal advice. This is for informational purposes. For real legal advice, you should speak with either Miller Mayer or your counsel to make sure that you're getting that. But yeah, the EB-5 program really is a great opportunity for those who have the ability to access it. It's not that accessible for everyone. The reality is that, $800,000 is an exceptional amount of money. And so going into that and making sure that you're able to do it, it takes a lot of prior planning. It takes a lot of saving. Obviously, it takes the ability to have access to that capital and multiple sources. But when done correctly, it really is a fantastic opportunity, because I think that the words that come up oftentimes when we talk about people, because CanAm is a regional center provider and we are a provider of EB-5 investments, that is our main business. But the words that come to us oftentimes are permanency, and most frequently in the last couple of years is urgency, because the reality is for people who want to have that permanency in their immigration status, the EB-5 program is a great opportunity. And, with the other pathways that they've been looking at, potentially for their immigration, seeing that there is a lack of it, there's been a ton of urgency in moving forward, which has really been demonstrated by how much interest and how much investment has been made into the EB-5 program itself. And, I'm going to have maybe Nicolai talk a moment about some of the opportunities that's available in the EB-5 program. But generally speaking, as someone is looking at making an EB-5 investment, they really want to look at some very important factors, and they want to make, in terms of selecting which regional center operator or which regional center operator's project to work with, they want to make sure that there are certain aspects in place to make sure that they do have the best chance of achieving those goals. Some of them are, because this is an investment that is meant to get their full immigration status and their repayment of funds. So when structured correctly, they're able to do that. CanAm has had fantastic success in getting both of those. But from the immigration side of it, certain things like a qualifying regional center must be in place. A regional center is a geographical designation. All the filings need to be put in place. Those need to be in good working order. You need to make sure that you have a project that has filed its necessary project level documentation. You need to make sure that the actual financials of the project line up with what you're looking for in terms of the conservative nature of its being structured. It can be structured in many different ways, but ultimately you want to make sure that you are meeting those goals. And from a financial standpoint, you see a good, solid protection of capital in place. And you want to make sure that ultimately you have a project in place that is going to meet the job creating requirements that are coming at the future stages of your investment, because you're going into this to make sure that you get your full immigration and not to get some intermediary steps. And so prior planning, both with your immigration counsel especially, but with your regional center and the structure of that project are paramount as you're looking to achieve that goal of permanency in your immigration. But Nicolai, I think especially as it relates to this conversation specifically, and one that comes up all the time for people, is the ability to concurrently file one's adjustment status, because this is not an opportunity that was always in place for the EB-5 program. Going back to your origins of the program, this is not something that was available. This is something that came along with the passage of the Reform and Integrity Act in 2022. So maybe if you'd like to talk a little bit about that and that opportunity, especially as it relates to Kristal's prior points about H-1B holders and doctors and other professionals.
Yeah, absolutely. So you're right. It was not a possibility to concurrently file before the passage of the EB-5 Reform and Integrity Act, which was passed in March of 2022. We call it the RIA. So the RIA made a number of significant changes to the EB-5 program. As I mentioned earlier, the program's been around since 1993. It's been extraordinarily popular and successful, but Congress wanted to make some changes and some improvements to the program, really take it to the next level, if you will. And they did that, I think, by passage of the RIA. One of the key changes they made there was to permit now, for the first time in the EB-5 program, concurrent filing. And what does that mean? It means that along with the initial EB-5 immigrant petition that you file, which is filed in a form called an I-526E, if an individual is in lawful non-immigrant status in the United States, like H-1B or like an F student, for example, they can, if a visa is immediately available for them. So if they are not from a country that has retrogression in any of the EP5 set-aside categories, and right now all of those categories are current, there are visas available. So if those two things are true, then along with the I-526E, they can file an adjustment of status form. That's filed in a form called an I-485. And it's asking the government to adjust a person's status from non-immigrant to immigrant, right, to become a green card holder. Now, of course, the I-485 cannot be approved until the I-526 is approved. And the I-485 is its own form. It's used across many different immigration categories, family-based and employment-based. So it has its own processing time, kind of independent from I-526E. Many people think that, you file the I-526E, and as soon as it's approved, my I-485 will be approved. It doesn't work that way, but it is a prerequisite for approval that the I-526E has been approved. But the government gives you two very key benefits while you are waiting in the United States for approval of your 485 or issuance of your green card. And that is temporary work and travel authorization. So along with the I-485, you can file an I-765, which is going to give you work authorization pursuant to an EB-5-based EAD card. Also, you file an I-131, which is going to give you the right to travel in and out of the United States on something called advanced parole. Sometimes these two benefits are issued on the same card, and we call that a combo card. It's really just a matter of convenience, having both of those rights evidenced on a single card. More often these days, we're seeing USCIS first approve the EAD, because that's typically what people want the soonest. And then second, we see the advanced parole being approved. But so what this grants somebody, the benefit that, say, an H-1B holder would derive from this is an independent right, separate from the H-1B status, to remain in the United States and work in the United States. So if there was, for example, a layoff, if an H-1B holder didn't have a pending I-485, they would have to leave or find another employer. And you referenced earlier, Pete, people often call with questions about EB-5, and there's real urgency, right? It's sort of an emergency situation. But with an EB-5 concurrent filing, they have a kind of fallback, right? We advise all our clients that if possible, we want them to maintain that H status if they can until they get the green card, because that hedges any potential issue that might arise with a 485 or the I-526. This is very important, and I think more important today than it's ever been. It's very nice to have that to fall back on if possible. Sometimes it's not possible. Sometimes there's a layoff and, but then somebody has that ability to stay in the US that they wouldn't otherwise have.
Right.
Right. So it is an independent way to stay in the US, and that is tremendously powerful and attractive for many H-1B holders. I get calls almost every day for people who are worried about layoffs or want to be entrepreneurial and go and open their own business, or just really want to have that hedge in view of many of the things that Kristal talked about. That's extraordinarily stressful just from a human psychological perspective, to have the specter of these changes hanging over you. And if you can have in your back pocket a fallback position that would allow you to stay here in the United States, maybe you have U.S. citizen kids or whatever your specific circumstances are. Not only is that powerful, as an alternative immigration strategy, but psychologically, it's I think extraordinarily beneficial for an individual. So concurrent filing really is something that has drastically changed the EB-5 landscape. Before passage of the RIA, it was only possible to file an I-485 after I-526 approval. But after the passage of the RIA, now a significant percentage of our clients are people that are coming to us directly in the United States, filing EB-5 in the United States rather than outside the United States. And that speaks to the benefit that a petitioner derives from concurrent filing.
Absolutely. Sorry, Chris. Oh, please go ahead.
No, I was just going to say, just sort of picking up on that. There are obviously a great many benefits that concurrent filing offers. I would circle back to what I was talking about earlier, which is that most people in sort of a private sector job do have to go through this lottery process that's specific to the H-1Bs. To H-1B numbers. But there are exemptions from the lottery. So the most common, I would say, is public colleges and universities. People who are working at those institutions and are in H-1B status do not have to go through the lottery system to seek H-1B classification. I would say maybe the most common or second most common to colleges and universities is nonprofit institutions like public hospitals that have affiliations in place with colleges or universities. So that's specific to the physician world. And that's why most physicians don't have to actually go through the lottery process because they're working at one of these nonprofit hospitals that's affiliated with a college or university. But nevertheless, most physicians in the United States do their training in what's called J-1 status, and then they have to get a waiver of a 2-year home residence requirement that then attaches to them. Waiver jobs can be quite competitive to secure. Additionally, waivers themselves can be difficult and time-consuming to obtain. So another strategy that we've seen in place for physicians in H-1B status that might want to do EB-5 is to pursue their residency in H-1B status while concurrently pursuing EB-5. So generally, we sort of advise physicians away from doing their training in H-1B status, and in particular specialists, because they run the risk of using up all of their 6 years of H-1B time before they've completed their training. But if you start your EB-5 process near the very beginning of your residency, this can protect you against that issue by enabling the physician to potentially even become a permanent resident by the end of their residency, as opposed to then starting the process of trying to find an employer to sponsor them. So it can be it could potentially be a very key strategy for someone in that situation. And remember that also then potentially enables a spouse to start working much sooner than they otherwise would. And of course, there are other ways that EB-5 and concurrent filing might help a physician or really any professional. And Nick and Pete both touched on this, but which is it does remove dependence on your employer for immigration sponsorship. So as I mentioned earlier, that's not a given. Employers are not necessarily required to sponsor you. And even if they do agree to sponsor you, a lot of employers have policies in place about the amount of time you have to have worked for them before they will sponsor you, or certain performance milestones that you might have to meet before they'll sponsor you. And so going the EB-5 route can ensure that maybe you don't have to wait for those milestones or those timelines in order to start on your actual permanent residence journey. And again, it could potentially get you spousal work authorization much quicker. Because let's say, for example, you're a physician and you are in H-1B status, but typically, even if your residency program enables you to do your training in H-1B status, they don't sponsor you for permanent residence. And a residency program is 3 years in length. So that's 3 years right there that a spouse would be without work authorization. So the other benefit that I would probably bring up that I think a lot of our clients really appreciate is that now that you can apply for adjustment of status and advanced parole and work authorization concurrently with the I-526E petition, an H-1B holder can actually utilize the advanced parole document in place of an H-1B visa and still continue to maintain their underlying H-1B status, meaning it sort of serves as a replacement travel document, which is really nice for individuals who maybe have a quick trip home but their visa has already expired in their passport. But they have an advanced parole that was granted perhaps pursuant to their EB-5 process. That means that they wouldn't necessarily have to book their appointment at the consulate, go to their interview, which is now required in your home country. And then wait the 2 to 3 weeks, best case scenario, to get the visa back in their passport in order to return to the United States. So that's a significant time save. And again, in line with Nick's point, that they are still able to maintain and extend their H-1B status, even if they use the advanced parole document in lieu of the H-1B visa. So that's a pretty big benefit because that means, of course, that should something go wrong with your adjustment of status application, you still are in that H-1B status to fall back on. So there's sort of a huge benefit there to having those opportunities available.
Absolutely. Absolutely. Very important. Thank you for sharing. So as we now look at potentially having some of these people who have seen EB-5 and they look at EB-5 as a real potential opportunity for them, something that would be beneficial for them going forward, it's also important to know, and we could talk a little bit more about the actual processes. A lot of that can definitely be discussed, maybe in individual consultations, but there's some very important timelines that are coming up on the horizon as well. When we talk about the urgency that people are moving with EB-5 with, a lot of this is dictated by these timelines. Some of them are known. We have clear views of those. Some of those are still being determined. So let me elaborate. So the EB-5 program is a pilot program. It's been reinstated many, many, many times. But the reality is that it is something that does need to be reinstated. It was just passed in March of 2022, and as crazy as it seems, because it felt like it was forever when they passed it, the program is currently set to sunset in September of 2027. All of us in the industry feel very confident and comfortable in the proliferation of the program, and we see that as coming, but it is something that would still need to happen, and it is something that's very much on the radar. For some more rapid deadlines that we're looking at are there was grandfathering provisions that was passed in the Reform Integrity Act in 2022 that are set to expire in September of 2026. So this doesn't mean that you couldn't still make an investment after September of 2026, but those grandfathering provisions that very important that can bring a little bit more comfort to you in terms of your decision-making process, those are currently set to mature a little bit later this year. Another very important deadline that some are aware, but some are maybe not. is that there is going to be a price increase of the investment amount for EB-5, because currently the price amount for the EB-5 program in general is $1.05 million, but for projects structured in a targeted employment area, it is $800,000, which is by far the most prevalent path that most projects will be sponsored in. So that investment amount will also be getting increased by an inflation adjusted index in January of 2026, January 2027, which will likely increase the investment amount by anywhere from $130,000 to $140,000. So a significant price increase will be coming. So things that the people definitely need to be aware of as they go forward. And these things that we all know. But there's also some things that we don't know in terms of the timing for which you could actually achieve your immigration benefits. Because your ability to concurrently file, as we have talked about many, many times on this so far, is not only for you to have a valid status within the country already, but for the visa that you're applying for in the EB-5 program to be current in its status as well. So the ability to concurrently file for many investors, especially those like Chinese investors, Indian investors who have a date of file action on the visa bulletin in the unreserved category, is that their set aside category, high employment, rural, or infrastructure, is also current. There has been all of these categories are still current, and we can see this now. Where the unexpected or the unknown factor comes in is that if there is a date of file action in any of those categories, if you are not current in your status in your other category, then you would not be able to concurrently file for an adjustment of status. Nicolai and Kristal could do a much more eloquent description of this, but I'm trying my best as I go through this. But this is an opportunity that is fantastic for people. But if and when data file action comes for these categories, that will impede your ability to concurrently file for an adjustment of status and change the time frame for which you're actually able to get your benefits from this. And the reality is that this is something that's going to be happening sometime in the future. Talking to industry experts, I think the best guess is that this could potentially be coming in 2027. Realistically, is a data file action has not occurred yet, not because of the amount of interest or investment into projects in the EB-5 program, but more so from the adjudication of actual visas. So if you look at some of the data from the investments that have happened over the past year, there has been significant investment, but there has not been the adjudication, which really has made this opportunity, which is a really, really important and really beneficial one, to concurrently file for an adjustment of status, available for a longer stretch of time. Nicolai, maybe if that's something you want to expand on, or maybe talk about how that would relate to the EB-5 process in general for someone who's looking to move forward.
Well, Pete, I think you said it very well and very articulately. It's a closing window of opportunity, really. I think if you know that you want to do EB-5, or if you want to have a conversation with us or with Pete about what the process is and whether it's something that fits with your overall immigration goals, I think September 30th, 2026 is a real deadline. I do think the grandfathering provision is significant, and it's nice to know that if the EB-5 program is not extended in September of 2027, your petition will still be adjudicated. As Pete said, our expectation is that the program will be extended. I mean, it has been many, many times since inception, and it's generally very popular on both sides of the aisle. Democrats and Republicans equally like EB-5. So we do think there's a high chance that it's going to be extended, but you never know in today's political environment. And so I think September 30th, 2026 is a deadline, particularly for those who have decided that they want to move forward. I mean, as I often tell people, I have never had anyone tell me they wish they would have waited longer to do EB-5. Right now we're sort of towards the end of May. We have a long weekend coming up. Is there enough time? That's, I think, perhaps the question that people have. 4 months is enough time. It's enough time to learn about EB-5, talk to an immigration attorney, figure out your source of funds, particularly if it's US based. We have enough time to typically structure a lawful source of funds for US based income. It tends to be a little simpler than money earned abroad. And then to choose a project. And within that time frame, 4 months is enough. Is 3 months enough? Yeah, we could probably do it in 3 months. 2 months, it's getting tight. 1 month, I think that's going to be very difficult. EB-5 is a somewhat complicated process. The immigration process, as we've described, is multi-tiered. Both the I-526, which is the investment part of it, and source of funds part, and then the concurrent filing. You have to get medical reports. There are extensive questionnaires. This is a process. And then there's the project selection process, which is also pretty significant.
Mhm.
Somebody who has not started the process in August, I don't know, it's possible, but it would be difficult. So I think there's time. I do think that people, should think about it, learn about it if they haven't already, and they can meet the September 30th deadline if they try. But the other, for those that can't, the next germane deadline, I think, is going to be the January price increase. That's going to happen. We know that it's in the RIA. And then we have September 30th, 2027. And I think we'll have good indications at some point about what Congress intends to do with the EB-5 program and so forth. But immediately, I think people should really be focused on September 30th, 2026.
Yeah, I agree. I think it's great advice, and really one of the first conversations I have with people who are at the earlier parts of the stage is, if you've determined that EB-5 is the pathway that you want to go to, you have to hire an immigration attorney immediately to start working on your source of funds documentation. Groups like yourselves do a great job, and you're able to move things along in a fairly rapid manner. It's a complicated process, and there's a lot of detail that goes into it, and it's warranted. I think we've all been seeing that USCIS, they can be strict in some of their interpretations on things, and working with a good law firm, making sure that everything is fully detailed is paramount. Higher plane that goes in is paramount. And as much as we love talking to people about our projects, we love talking to people about our company, sometimes it's there. There's maybe the reality is these are things that should be done in concert with each other. Sometimes I think there's almost a thought process of, oh, let me pick my project and then let me go ahead and hire an immigration attorney. Doesn't really work. It never really works that well in terms of working with good regional centers with good projects, because they'll generally move at a pace that wouldn't necessarily allow for that. You want to make sure that you're able to use your time wisely. And using your time wisely is having your source of funds done, because that gives you the ability to actually act on a project that you feel like meets your need, that you like. Because otherwise you could end up in an unfortunate situation of continuously missing deals because you haven't quite completed this pathway yet. I think if I could give, and I give this, this advice to most people I start off on who haven't yet, hire an immigration attorney and talk to different regional centers about their platform. Because, their platform, good regional centers are going to structure good projects. That's the way that this generally works. Just like good law firms are generally going to do good law work. I would have all of your preparation done early in terms of your immigration work, as well as your work at different regional centers, and then get more into the details of a specific project once you are further along or completed with your source of funds, because that's how you could really actually move forward with it. And especially as we're looking at this time frame that's just going to be compressed. You're talking about 4 months if you want to have that timeline. The time to really start that planning really is now.
I was just going to add one thing, which is, I think a common myth that I hear and a common question I receive, which is that I think a lot of people think, oh, well, if I do EB-5 and I move forward with this process, am I foreclosed from pursuing other options for permanent residence? And the answer is no. Anyone can have as many bases of eligibility for permanent residence as they qualify for. So we have people who have, an EB-1A, I-140 petition approved. They do EB-5. They also have a perm that their, employer has done on their behalf. And that is absolutely permissible. And so if you have the opportunity to have your employer do a perm for you, but you do have the capital to do EB-5, there's absolutely no reason that you shouldn't pursue as many pathways as you can in order to, increase your chances of getting permanent residency. And ultimately, you're only going to get one green card, but you can have as many bases of eligibility as you potentially qualify for. And so, I don't want people to think that, oh, if I look at EB-5 and I go down this pathway, I'm somehow foreclosed from my employer doing something for you. You're absolutely not. You should definitely, pursue and explore all paths in parallel.
Yeah, and if I could make a related point, and that is we've been talking about doctors and H-1B holders as potential beneficiaries of what EB-5, of the benefits of EB-5 and concurrent filing. But, a student as well can definitely benefit from EB-5, and we do a lot of student consultations. Typically, those students are coming to us when they're graduating, right? Maybe they're nearing the end of their OPT, and they need some basis. They weren't selected for the H-1B lottery, and they need some basis to continue to live in the United States. And that's fine. That is an immigration strategy. There are things that we have to talk about in terms of maintenance of status and risks and so forth. But I think it's important for students to understand they can start the process even earlier than that, right? So if even when they're freshmen, they know that they're going to have F status for a significant period of time, which is a nice thing to be able to maintain. Starting EB-5 early is not a bad idea because by the time you graduate, depending on what country you're from, you may have that green card, and you certainly may also have, work authorization. Now, there are some complexities and nuances in there that probably beyond the scope of this webinar. But the point I want to make is that EB-5 as an alternative and supplemental immigration strategy is not just for doctors, not just for H-1B holders. It's really for anyone who's in the U.S. in lawful non-immigrant status with a visa available.
I agree. Planning is always paramount. Just like planning for a good project, from the investment side of it is, making sure that you have the protections in place from an immigration standpoint, making sure that you have the financial protections in place, like your collateral, like your stats and account bill stack, your feasibility of a business plan, all those sorts of things. Planning is the best thing that you can do. For us as regional centers, for you as an individual investor, for your immigration journey, it's the best thing that and starting early on it is hugely important. And obviously, we're happy to talk about these sorts of things. I know Nick and Kristal are as well. Having all these sorts of things planned out and have a strategy is the best thing that you can do, because you don't want to start moving forward with any of these processes without things, so you can have all the interactions of them make sense. And I think that this is great practical information that was being provided. Before we move on, Nicolai or Kristal, do you guys have any, final thoughts to share in terms of this process for people?
No, I think that was pretty much my final remark. I do think it's important, though, as Nick said, to sort of explore this option now. Because while it is available to you presently, for those of you, for others, it may not be available next year, given these deadlines that are coming up. So, again, I do think it's worthwhile if you do have the potential capital. Again, because you still can have other options available to you. It's important, though, to explore, every immigration opportunity that you have, really, if you want to stay here.
I second that. I mean, I think the message is if there's interest, you really should begin exploring now and making decisions now. I think there is enough time, but time is running out. I do think long term we'll see an extension of the EB-5 program. It just does too much good in this country for it not to be extended. In my view, that's a whole other conversation. But the immediate benefit is there. Look, there's a lot of immigration uncertainty and turmoil in this country right now. There's no question about that. And, going back to my point earlier about the psychological impact on families, you can't overstate that enough. Kristal and I speak to our individual clients every day that are dealing with these things, and it's psychologically taxing. I mean, it is. It can be where before in the past somebody could just sort of without thinking much about it rely on an H-1B, and suddenly there are questions about that for myriad reasons. If you can get a backup to that, we know that what EB-5 provides is it's not only immigration. There is an element of psychology built into that as well that I wouldn't want to understate for people. Yeah, it's an opportunity. And if people are interested, reach out to us. We'd be happy to talk to them and explain the next steps forward. In particular, Kristal's understanding of doctor specific issues and J-1 visas is unparalleled, far exceeds what I know. I know a lot about H-1B, but that is a subspecialty in the industry. So take advantage of their knowledge base.
Couldn't
And
agree
thank you.
more.
Yes. And thank you everyone for joining.
Well, thank you guys both for joining. This is really helpful. I think this is a lot of information. And please reach out to Nicolai or Kristal for any immigration questions. We'd be happy to talk you through CanAm's platform as well as our projects, both current and upcoming. Thank you all for joining. Have a great rest of your day.
Thank you, Pete.